Buenas tardes. Voy a presentar a la profesora Anna Veneziano. De Anna Veneziano debo decir que estamos tratando con una persona, como han visto ustedes por su intervención esta mañana, de absoluta solvencia. Una persona de absoluta solvencia. Por su formación, por los puestos docentes e investigadores que ha ocupado y por su actividad profesional. Seré extremadamente breve. Primero, por su formación, es licenciada en Derecho en la Universidad de Roma, La Sapienza, una universidad muy querida para el área de Derecho Internacional Privado de la Carlos III, puesto que en julio tenemos que ir a la presentación del Liber Amicorum Angelo David, en el que hay por lo menos 5 capítulos nuestros. Luego estudió un máster en Derecho en la Yale Law School e hizo el doctorado en la Universidad de Florencia. En cuanto a los puestos docentes e investigadores, me limitaré simplemente a decir que fue profesora de European Law Property en la Universidad de Ámsterdam de 2013 a 2018 y que es full-time profesora ordinaria, catedrático de Derecho Comparado en la Universidad de Teramo en Italia. En cuanto a su actividad profesional, debo decir que es persona especialmente adecuada para hablar de la Convención de Cape Town, porque fue miembro de la delegación italiana tanto en la negociación del Aircraft Protocol de 2001 como del Space Protocol del 2012. Finalmente, debo decir que ella actualmente es Deputy Secretary General de Unidroit y que he tenido por la semana pasada, durante la reunión del Government Council, la oportunidad de ver cómo Ana es una persona multitarea, es decir, es capaz de hablar de cualquier tema que haya sido tratado en Unidroit en los últimos años y hacerlo siempre, con independencia del tema, con la misma soltura. Es una persona que tiene, además, un trato extraordinariamente afable y hace que cuando uno llega a un centro de investigación como es Unidroit, el Instituto para la Unificación del Derecho Privado, uno tenga la sensación de que se encuentra en el Max Planck del sur de Europa. Teniendo en cuenta que hay una representante del Max Planck de Luxemburgo aquí, digamos que Europa está no condenada, sino encaminada a tener tres excelentes centros de investigación para nuestra área de conocimiento y, por supuesto, para derecho mercantil, que serían el de Hamburgo, que es donde nos hemos formado la mayoría de los seniors de la vieja generación, los que conocimos a Zweigert, a Drobnig, a Basedov, que es solo 5 años mayor que yo, y que, por consiguiente, no sé si hemos escrito una página en la historia, pero sí que estamos ya en la historia más que en el presente. Luego está el Instituto Max Planck de Luxemburgo, de Derecho Procesal, que ha supuesto, bajo la dirección de Burkhard Hess, pues un aire de renovación que es oportuno, visto que hoy tenemos 18, al menos que yo haya contado, si no me olvido alguno, 18 reglamentos comunitarios que elevan realmente el derecho internacional privado en Europa ya a la categoría de dogma, hasta el punto de que, como Javier Carrascosa y yo hemos sostenido de palabra y por escrito reiteradamente, el centro hoy del sistema de derecho internacional privado ni lo es la Constitución española, ni lo es el Código Civil, es el Tratado de Funcionamiento de la Unión Europea y los 18 reglamentos satélites que tiene. Y por último estaría pues un clásico. El clásico sería Unidroit, que, como he dicho esta mañana, es el Olimpo de los jusprivatistas. Y bueno, yo creo que de la mano tanto de Anna Veneziano como de Ignacio Tirado, nuestro secretario general, pues probablemente en no demasiados años lo veamos. Tiene ya una biblioteca envidiable, con unas colecciones que hoy no se pueden encontrar más que en el Max Planck de Luxemburgo o aquí, e importantes donaciones. Y dicho eso, como sabéis, soy un peligro, soy un hombre incontinente, de una, como dicen los italianos, de una verbosità pericolosa. Dejo con el uso de la palabra a Ana. Muchas gracias por estar hoy entre nosotros. Thank you very much to be among us today with us.
Thank you very much, Professor Calvo Caravaca, first of all for your very flattering words of introduction, and secondly also for the invitation to be here. We are all very honored, and it's a great pleasure to be here. Now, my second general remark is, as you can hear, I will be speaking, unfortunately, in English, with my Italian accent, which maybe makes it more acceptable. And and as you also see, there is a complete change of subject matter already anticipated by the general presentation of the Secretary General, because from soft law instruments, Derecho suave, I think I heard, which is wonderful. I have to use it also in I would like to introduce this into Italian. It's much better than soft law. So we now are in front of the hardest possible law, a treaty, which has to be negotiated first and then implemented by states. And the subject matter of the treaty, as already pointed out by Ignacio, is to introduce a modern, innovative international regime to facilitate financing and leasing of certain types of high-value equipment. And this afternoon we have 3 presentations on the Cape Town Convention, not just only one. There is a reason for that. The reason is that this is really a flagship instrument of Unidroit, and it is one of the most successful treaties in this area of commercial law ever. And so it does deserve some attention. And the second reason important is that Spain is particularly interested and involved in the 3 protocols that will be addressed today. First of all, it is already a party to the aircraft protocol, and there might be issues of implementation that are very interesting to address. Secondly, it has started looking into the rail protocol and its implementation. And thirdly, it has participated very actively in the negotiations of the MAC protocol. We are have in front of us the column of that participation, both in the study group and also in the governmental expert committee meeting. But without further ado, I will go to the matter at hand, also because I would like to leave some room also for the other presentations. And before looking at why Unidroit developed this instrument, which might be interesting also for an academic debate, I would like to point to 2 innovative treaty design elements that are 2 of the reasons why the Cape Town Convention was so successful. So the first, I'll go here. Okay. So the first one is that the Cape Town Convention system is a flexible architecture. There is a main convention, the Cape Town Convention adopted in 2001, and then we have a list of protocols under the convention. The aircraft protocol, which already entered into force in 2006, covering airframes, aircraft engines, and helicopters. We have the Luxembourg Rail Protocol, adopted in 2007, covering railway rolling stock. We are still within the 7 years period more or less. Maybe we have gone a bit over it, but the rail protocol is on the brink of entering into force. We only need one state ratifying it. And then the space protocol, which was adopted in 2012, covering satellites and their components. And last but not least, the mining, agricultural and construction equipment protocol, for which a diplomatic conference, as was very many times said today, is to be held in November 2019 in Pretoria. So you see here different levels of development of the protocols and therefore also the treaties, a full implementation on the brink of entering into force with all the issues relating to compliance and implementation of it. For example, the registry and the supervisory authority for the registry. And then we have a text which has to go to be approved by the diplomatic representatives of states in Pretoria. Now, why is this flexible architecture interesting? Because the general rules are contained in the convention and they ensure the uniformity. But thanks to the protocols, these rules are adapted to the different categories of equipment and also to the different markets. One example of the categories of equipment, since the system is based on registering the international interest on the equipment, then for the different types of equipment, there might be different ways that this univoc identification of the equipment for the purpose of registration is done. And so the protocols have to have different rules on that. On the, when we look at the market, then we see, for example, that industry told us that in the market for aviation financing, engines are separately financed and therefore they figure as autonomous objects on which an international interest can be created, while this is not the same. This is not the case for the rail protocol because we did not get the same information from that particular industry. And the protocols may derogate to the convention and the rules of the protocol prevail, and the uniform regime only enters into force for a contracting state as regards the specific category of equipment in relation to a specific protocol. This is important because usually when we have a general text and then we have some protocols in addition to it, these additions are specifying certain technical elements. In this case, they are really modifying the main rules and they have to be read as one text with the general convention. Now, the second important general treaty development issue that I would like to address is that the adoption of the CTCN protocols was a highly inclusive process, including, of course, especially at the first stage, academics, professional lawyers, other experts, but at the level of the governmental expert committees, which are always present, governments and regulatory authorities, for example, the civil aviation authorities in the case of the aircraft protocol. There was also the involvement of specialized intergovernmental organizations, for example, the International Civil Aviation Organization, which is the supervisory authority of the registry for the aircraft protocol, and the OTIF, which is the organization dealing with railways, and this is the secretariat of the future supervisory authority for the rail protocol. But the most important element is the driving role of industry. And it's interesting to see that the industry stakeholders have been involved before and during the drafting and the negotiations through the creation of special working groups, the aviation working group, the rail working group, the MAC working group, but they were also involved in the subsequent implementation, for example, as advisors to the registry. Now, we come to why we have the CTC. I think I can be rather quick on this. We start with a particular area, the area of aircraft financing and aircraft aviation market. Why? Because until the 80s, the subject matter of secure transactions had been discussed in other organizations, for example, UNCITRAL, at a general level, and then the result was that the different legal systems were not compatible, and it was very difficult to reach common rules for all of them. So what Unidroit started to do was to look into specialized fields where this uniform law in the form of treaty made sense because it could solve a real problem of that industry. And this is what happened for the aircraft industry, and according to Unidroit, the same reasoning could be applied for other high-value, highly mobile and equipment for which financing is needed. So what is the traditional scenario until the 80s, maybe late 70s in the aviation industry? State ownership mostly, high regulation, low risks of default. Now, what happens later on is that there is a shift to private ownership, especially in certain legal systems and countries, much lower level of regulation, and a much higher risk of default of companies. A dramatic expansion in the level of commercial air traffic, and new actors like start-up companies which need to finance their activities. So how do you finance your activities? You go to a financier, and unless you already have liquidity. For example, the classical example for us in the aircraft industry is Lufthansa. There is no need to go somewhere else to find financing. But if you need to finance your activity, you try to find a financier, and usually the financier, especially in a cross-border situation, and especially if you come from a developing country, asks for a security, more predictability in the outcome of the transaction, and how this is done usually in legal systems. Well, here we have assets which are very high value, and therefore the debtor can use the value of these high value assets to give the needed security. But the problem is that those devices that allow creditors to use the value of the equipment to have added security are very different in the different jurisdictions. And I would like to show one example of a cross-border problem in the case of aircraft, which makes this issue clear. So it is taken from a real case, but a bit modified in order to make it adequate to what we are discussing. The example is a situation where there are some aircrafts owned by an English company and leased to an Armenian company, at least some of them. The English company had granted an aircraft mortgage on the aircraft to obtain financing from a US bank, and this mortgage was an English mortgage because we don't have a Cape Town scenario. And at a certain point, because of default, the US bank wants to enforce its mortgage. So what happens is that the English court, which was seized with this matter, has to decide which is the applicable law. And in this case, there was even a dispute of what was the connecting factor, because is it a place of registration, the country of registration, is it the lex recite? And the court decided for those matters of enforcement, it is the lex recite. And so the question is, where is the aircraft at the relevant time? And the problem is that for one aircraft, nobody knew, but depending on where the aircraft was, the solution the outcome would have been different. In the Netherlands, the English mortgage would not be valid. In England, the English mortgage would be valid. So it's a total situation of uncertainty for the banks, the US banks, which of course does not help and would either prompt banks not to extend a loan, or they would extend a loan but at a higher rate. And this is just to make it a little bit nicer. There is a part of the world, and it could be more complicated than what we said, because we could have a Russian lessor of aircraft, and then the aircraft is operated in India by a lessee, and then the lessee gives rights to possession and control to a subsidiary in Thailand, and then the aircraft moves to China, and in China there is a local creditor. And if there is a default, who is going to win in this situation? It is highly unlikely that without the Cape Town Convention, the Russian lessor of aircraft has any kind of results. Now, to recap, first of all, remove obstacles to cross-border use and enforcement of asset-based financing devices because of a very traditional problem, the problem of the lex recite, of the conflit mobile, of the high mobility of these goods. And secondly, because of it's not just this, but added to this the fact that secure transactions law around the world differ widely, even within civil law systems and even within common law systems. But there is a second issue, which was as important for the success of the Cape Town Convention and Protocol. To improve generally the predictability of these transactions in order to lower risks and thus to lower the cost of credit. And this irrespective of the fact that it's a cross-border transaction or not, because many secure transactions law are not effective and do not offer, at the moment, sufficient predictability to the creditor. And we see that many transactions under the Cape Town Convention are actually not only cross-border, but also internal transactions. Now, we have then the mantra, the slogan, more certainty, lower risks, lower costs. And I think that Ignacio, the Secretary General, has already shown our wonderful maps. We love to show those maps, so I'm not going to show you the map again, but only for one reason. You see that it's 79 and 76, because the Secretary General was right. I was wrong. We received the documents, but we did not yet look through them, and therefore we don't know whether this will be accepted. But the thing the most important thing I wanted to point to is the quantifiable economic benefits of the aircraft protocol. We are talking about the aircraft protocol, deriving from the lowering of the cost of credit. Why? Because it is not just the single creditor who would have an enhanced predictability and therefore would be able to extend credit at a lower rate or to extend it at all. It is actually more generally the financing community that has recognized the importance of the Cape Town Convention and the Aircraft Protocol through the OECD, which is the umbrella organization for the export credit agencies, but also through an improved rating in recourse to capital market debt financing, which means that more companies, not just US companies, can access US capital markets and through certain certificates that are added to leasing agreements, and they would be awarded ratings that are more favorable if their country is a party to the Cape Town Convention than when the country is not a party, or they might even not be able to access that market at all. And I think the example which is always given is the fact that the British Airways got a worse deal on the capital markets than Canadian Airlines, and British Airways, Air Canada, sorry, and of course usually usually the market says that British Airways is a more solid kind of company, and it is actually, but because of the fact that the UK had not ratified Cape Town at the time, and Canada had, the different provinces of Canada had, then Air Canada had a better rating and a better deal, and therefore the British Airways knocked at the door of the British government and asked for ratification. So you see that, again, the importance of convincing the industry that this is something useful for them. I have to say that this is linked to a special way of ratifying the Cape Town Convention and Aircraft Protocol, which means that certain declarations that give to creditors enhanced rights should be included in this ratification, and this because the market relies on these declarations and these particular rules in favor of creditors. Now, I'm not completely finished, but I'm almost there, because I would like to go through some elements of the Cape Town Convention and partly also the protocols, legal rules, in order to see what this is all about, and also to pave the way to the presentations on the specific protocols afterwards. So the first point I would like to make, I think might be interesting, especially for those of you who are private international lawyers, because it's the connecting factor that is used in order to determine the territorial scope of application of the convention and the protocols. And we see Article 3.1, the convention applies when, at the time of the conclusion of the agreement creating or providing for the international interest, the debtor is situated in a contracting state. So we see that the connecting point is the debtor. It's not the creditor. The location of the creditor is totally irrelevant. And this test applies only once in time, so if the debtor moves, the convention continues to be applicable. And this is very important because it makes two things clear. One is that it does not need to be a cross-border transaction. It could also be an internal one, because the creditor could be in the same country as the debtor. It doesn't make any difference. And secondly, the second important point is that there might be, the interesting point is where the operator, for example, of the aircraft is located. This is the debtor, of course. And so this would allow the operator to get financing at good rates, also from financiers who are located in countries that have not ratified yet. This is, for example, the case for Germany. Germany is not a party to the convention, but at the same time, many German financiers have indeed made use of the convention and application of it because of this reason. So now, how does this work? What are the key legal features of the model? This is just an overview. I'm not going into the details, of course. And if there is anything particularly important for the other two presentations, my colleagues will give more details on that. So we start with the first one. The first point is that parties to a financing transaction can create an international interest, which is completely autonomous from what you find in national law. There does not need to be an equivalent interest or right within a specific legal system. And this, according to the text of the convention, this international interest derives from a security agreement, or for a sale with retention of title, or a lease. And this is very interesting for us because it means that the Cape Town Convention has embodied a functional approach to secure transactions. The important thing is the function of the device and not the form. There are some rules in the enforcement that are different for retention of title or lease, but they are limited. The most important rules in priorities, for example, and also in the creation of the international interest are the same. And then lease encompasses also operating lease. And this because it was considered to be essential in the aircraft industry to have this, and it was felt that also for the other protocols it might be useful to do that. Second important point, what do you do with this international registry? This international interest. You register it into an international register. It's a dedicated one, different for each protocol, asset-based. So this is the special peculiarity of this registry, and it's wholly electronic, and therefore you have both transparency and predictability. Third point, when the interest is registered, it is enforceable in contracting states. And more specifically, there are clear priority rules. So the registry is there to create a very clear system of priority rules. First in time, the first one registering will prevail over an unregistered, but also a later registered interest, and also as against interest in national law. There are certain exceptions, but they are clearly identified and very transparent. There are, and this is a core issue in Cape Town and aircraft, but also in the other protocols, effective enforcement measures, effective default remedies. If the debtor defaults, the creditor may accede to effective and swift enforcement measures, including out-of-court remedies, if a state so allows, and advance relief pending final determination during court proceedings. So it's not only outside of courts, but also within courts that you can have a swifter resolution of the enforcement. And last but not least, effective insolvency as against the debtor, buyer, and lessees. And the last general key, feature is that states may make policy choices through specific declarations. You know that treaties may have reservations, states not wanting certain provisions. Under the Cape Town Convention and its protocols, you cannot make any reservations, but you can make a number of declarations. And the declarations are different and have different effects. I will point only to two types. The first one is an enabling one. States may protect specific national interests through certain declarations. For example, under Article 39 of the Convention, states may declare that certain non-consensual liens, privileges, that would prevail over a registered international interest, even if they are not registered and even if they are not known to the parties involved. And what are they? Usually, if we look at the practice, they are repairer liens, they are employees' rights for social security or their wages, and of course it depends on the state. It's a question of policy. We cannot have a uniform system of liens, but at least they are transparent. At least you have some transparency, not a lot, but at least the creditor can ask for more information. And then it is possible for the state to enhance the provisions of the convention, opting into certain rules that give creditors more rights. And this is what triggers then the good rating and especially the Cape Town Convention discount. So some advantages are there even if those declarations are not made, but most of the economic advantages are there when at least some of those declarations are made. And then there are additional possibilities provided by the rail, space, and MAC protocols, so this is already a hint that I have to stop talking and leave the talk to the experts on these other protocols. So thank you very much for your attention. And this is all.